Uh, as you will have just heard, we'll start the recording now, but we're just waiting for a few more people to join us. We're recording because a number of people had asked us to do so, given that they were unable to attend at this time. Thank you so much to everyone who's here already. We are seeing that a lot of people are joining at once, so we will wait for another 1 to 2 minutes before we begin the community debrief.
Welcome, everyone. We'll be starting in a moment. I've put some welcome messages in the chat, and thank you for joining us today.
Wonderful. Well, we know that people are still coming in, but we want to respect everyone's time today. So we'll begin this community debriefing session co-hosted by the Neighbourhood Group Community Services and the HIV Legal Network. We thank you all in advance for joining us today on this virtual platform. And please note again that this webinar is being recorded for those of us who could not join us today. First, today we are coming together on this virtual platform from all across Turtle Island, the lands and unceded territories of many different Indigenous groups and communities who have respected and cared for this land since time immemorial. We also welcome any international visitors to this space. As people committed to addressing ongoing injustices and health inequities, we must recognize that many of the harms experienced by Indigenous peoples on these lands are the result of the history of colonization and its ongoing impacts, and that these institutions and practices must be dismantled and reshaped. It's also critical, particularly for this conversation, that we acknowledge the legacy of anti-Black racism and its relationship to criminalization and punitive laws and practices. We recommit together whenever we come together to repairing harms and working towards a more just future for all.
Good afternoon, everybody, and thank you for joining us today. My name is Lena Gibson, and I work for the Neighbourhood Group Community Services. We are an organization in Toronto that delivers innovative anti-poverty, social, community, and health programs to over 45,000 people annually across the city. We are the applicant in the court case. We are here to discuss alongside two very brave individuals, Katie Resendez and Aubrey Fogg, who we are proud to know. The Neighborhood Group Community Services took action against the Community Care and Recovery Act so that we and other supervised consumption sites in Ontario can continue to prevent overdose deaths and improve the health care of people who may be struggling with problematic substance use.
And I am proud to be one of two co-executive directors at the HIV Legal Network. Our organization works to promote the human rights of people living with HIV and AIDS and other communities disproportionately affected by HIV, punitive laws and policy, and criminalization. And we do this in Canada and around the world. We've been working on issues related to drug policy for decades. In this particular case, we're proud to partner with the HIV and AIDS Legal Clinic Ontario, which you may also know as HELCO, to intervene in the case to provide specific evidence about the disproportionate impacts of the CCRA and the closing of supervised consumption sites on people living with HIV, women, and homeless people who may use drugs.
A couple of housekeeping items. We plan to host this session until 12:45 with time for questions and answers. It is a webinar format, although we have enabled the chat as well. But we prefer if you ask your questions through the Q&A so that everybody can see them and so that we don't miss anything. We will also periodically insert documents that may be of interest in the chat with links. As Janet mentioned at the top of this session, we are recording it and we will put links to the recording on both of our websites this afternoon after this session has completed.
And we wanted to make this webinar as barrier-free as possible. And we know there are many questions within the community around this important case. While the webinar is intended to be a community debrief, we know already that we do have some members of the media here today. We ask only that you identify yourself, including your name and media outlet when you ask your questions, please.
And finally, as this is an ongoing court case, and one that is incredibly important to many people across this province and this country, there may be questions that we cannot answer. Thank you for your understanding.
So, on to the show. Today, our format will be as follows. Bill Sinclair, CEO of the Neighbourhood Group Community Services, is going to provide his high-level reflections on the past 2 days. Following Bill's reflections, Sandra Ka Hon Chu, my co-executive director at the HIV Legal Network, will help us to better understand what the Community Care and Recovery Act is, briefly, what took place in the courtroom on March 24th and 25th this week, including general comments regarding the arguments of the applicants, the intervenors, and the respondent, or the province of Ontario. And finally, she will speak to us about what we may expect in the days and weeks to come. And again, as this is an ongoing case, we're going to try to provide as much information as we can, but there are simply things that we do not and cannot know at this point.
Pass it over to Bill Sinclair, our president and CEO at the Neighbourhood Group. Bill?
Hi, everyone. My name is Bill Sinclair at the Neighbourhood Group. Thank you for joining us today. We've worked hand in hand throughout this entire process with HIV Legal Network, and they've been so supportive of the Neighbourhood Group in navigating these waters that we're not familiar with. So thank you. And we had talked that when we discovered that the hearing wasn't going to be streamed to the public, and so most people wouldn't be able to attend or see it, that we would hold a debrief the day after for many people who are interested. And many people are interested in this case and are interested in what happens. And we will continue to try to find ways through webinars or social media or the traditional media to share updates and information, because it is so important to people. I'm just going to take a brief look back. So the Community Care and Recovery Act was passed in December, and a week following, the Neighbourhood Group and our two co-applicants put in our charter challenge. because we feel that the legislation will harm people and was wrong and is infringing upon our charter rights as an organization and as individuals. TNG has never done this before, and so this has been a real learning exercise for us. It's also been a very intense time period. So we are pro bono lawyers who wonderfully are supporting us to do the Charter Challenge, but also the government lawyers agreed that we want this to go through as quickly as possible, and we were aiming to do the hearing before the March 31st deadline, because it is important and it's about people's lives. So it's been a very compressed time period to do all the information, and HIV Legal Network has their website is a wonderful repository of information about the different steps, the evidence that has been submitted, both from ourselves and the intervenor groups. So intervenor groups are neutral groups who have useful information that the court needs to know. I'll let Sandra talk more about that from a legal perspective, but they are groups who provide evidence to the court so that they can have a full picture of what's going on. And that demonstrates the level of interest in this case, that there were 8 intervenor groups who had important information that the court needed to see, as well as our submissions as the applicants, and as well as the submissions of the government defending the law. I would just like to start by thanking our lawyers pro bono who volunteered their time and effort, hundreds of hours of time and effort and thousands of pages to support us to do this case. Again, this is all new to me, but they have been fantastic. And I will just say, as from the start, I feel that we were given the opportunity to put all the evidence in that we felt needed to be heard. And we had opportunity, even though it was rushed, to put forward our case and our arguments. And I thank the lawyers for doing that in such a professional and smart way. I also want to thank the intervenor groups who came forward and in a very quick, rushed way, were able to put in useful information, perspectives that are from beyond TNG that the court needed to hear, and that who all attended the hearing this week and who all participated in making sure that important information is presented so that we can have the best possible outcome. And I want to thank our very engaged court, who was clearly on top of this case, involved in this case, listening and asking questions. So we thank that very much. This was my first time in court. And so I thought I would just share for those who couldn't travel to Toronto and visit. So it was in an unusual courthouse. It was in a building I wasn't expecting. It was in the Canada Life building. I didn't know they have courtrooms there. And unfortunately, the courtrooms are smaller than I anticipated. We ended up in what seems to me an unbelievably small courtroom. And in fact, at the beginning, there was no way we could fit in it. And in fact, even all the lawyers for the case, the lawyers for the applicant, the lawyers for the government, the lawyers for the 8 intervenor groups, there weren't even enough chairs for them, let alone myself or the other co-applicants or all the interested people who wanted to attend. So the court did open up an overflow room, a second courtroom for people to sit in, and that quickly filled up, and they had to open up a third overflow room. So there was a mix of formality in the court, but also excitement of people who wanted to hear and wanted to participate. There was possibly 100 people who participated in this case, including lawyers and interested parties and witnesses who had previously given evidence but didn't necessarily at the hearing. So I just wanted to share that kind of feel that there was multiple rooms going on. There was strong community support and people who have interest on all sides of this case. Not everyone agrees with us as applicants, and their other viewpoints were represented as well. And I want to thank the media who were strongly present and present for the entire 2 days to cover the case and ask questions, to listen, and to meet with many of the parties and talk to them. So it was an exhausting time. Lots of voices. Bill, we were chastised for being too loud. The overflow rooms, we were told we were too loud for the courts. But anyway, so there were a lot of people and a lot of people talking and wanting to be engaged. On the first day, we had a rally at the lunch hour of supportive people from across the city and outside of the city as well, who came with banners and signs and spoke about why this is important to them, because they all couldn't even fit in the courtroom either, but they did spend their lunchtime to come and to show that support. And thank you again to the media for covering that, and the media for doing interviews and doing stories on that first day. So that's sort of the layperson's view of it all. We listened in day one, is when we as applicants could make our case. Part of day one and day two was when the intervenors, the neutral groups, were able to give their perspectives that the court needed to hear and were given time and questioned by the justice. And then day two was the government defending the law and with their arguments. And it was a very it was a lot of listening, a very intense 2 days. And again, thank you for everyone who participated. And I'm sorry for those who couldn't come. We were disappointed because we know that this case touches everywhere in Ontario, Thunder Bay, Ottawa, Guelph, Kitchener. And I'm sorry that there wasn't a way for people in all the cities to participate, and hence the debriefing today. But that's probably enough. I've taken enough of your time, but I want to give you a picture of what it was like. Our friends at HIV Legal Network and our friends at TNG did some social media posting during the 2 days. So you can look for it on Blue Sky and X and Instagram. We tried to share what information we were able to for those who couldn't be there in person. Please ask questions in the chat, but I'm going to turn it over to Sandra, who's going to give more of a summary of the legal arguments that we heard, which I cannot speak to. Thanks.
Thank you so much, Bill, and huge gratitude. I want to echo the gratitude you've shared to everybody, including the Pro Bono Council, all the allies that came out, and site staff who came out on Monday and Tuesday over a long and exhausting 2 days. I'll just go over quickly. I thought I would just start quickly with a very quick overview of what the CCRA is and the focus of this case, the provisions that are the focus of this case, a very quick overview of what the applicants' arguments were, which I think you're already mostly familiar with, and then focus my remarks on what Ontario argued, because I think that would be new, might be new to much of the audience here today. So in short, the CCRA, the law that Bill mentioned, which was passed in December, the subject of this lawsuit, there's one piece which the government described as a buffer zone, the 200-meter rule that prohibits any sites from operating within 200 meters of a school or daycare. That's one piece. The other piece, which is at issue in this case, is the requirement for the province's approval to request a federal exemption or to renew a federal exemption for a site to operate without risk of criminal prosecution. So in order for any site, for any staff and users of a site not to get arrested or charged with possession for personal use or trafficking, whatever happens on the premises of the site, they need an exemption from the federal drug law, the Controlled Drugs and Substances Act, to operate without risk of prosecution. That's a separate process that goes to the feds, but the law requires sites that are municipally funded or supported to ask for the province's approval to get that permission. So 200-meter rule, and then this prohibition on municipally funded or supported sites from getting that exemption. So what TNG and the two individual applicants argued was these provisions violate their charter rights to life, liberty, and security of the person. I think the arguments are very clear there. It increases the risk of death by overdose. It forces people to inject or use their drugs in ways that could contribute to higher risk of infection. It forces people to consume outside of a site, which exposes them to the risk of criminalization because the decrim bubble is inside the site. When you're outside, you could be risking arrest and criminalization. They also argue that it violates their Section 15 rights, which is a right to be free from discrimination. And the applicants argued that it imposes a disproportionate burden on those experiencing substance use disorder, which is considered under Section 15 of our charter an enumerated ground on the ground of disability. They said that this law deprives people who use drugs with substance use disorder of the services they need, and that reinforces stigma. And then they also mentioned the intersecting grounds of people who use drugs who are also women, racialized, have other mental health and physical disabilities. The other piece of their charter argument, their constitutional argument, revolved around the powers of the province versus the powers of the federal government. So they said, even if the court says this law doesn't violate the charter, it violates the Constitution, because under the Constitution, only the federal government can make criminal law. And with this new legislation that the province passed, Ontario is attempting to usurp Canada's criminal law power. And at the very least, even if it doesn't usurp that power, it's frustrating the purpose of the federal criminal law power by making it harder for sites to operate. And so they're arguing that the province doesn't have the authority to limit that SESs from being implemented when the power for that resides with the federal government. So that, in a nutshell, is what TNG and the two individual applicants argued. So I'm going to try to distill. This is what just my personal reflection on the second day of the hearing. That's a lot to distill into 10 minutes, but these are some of the things that I thought was interesting that Ontario argued. One of the really important things I argued was the evidence about supervised consumption services and its benefits is contested. They asserted that the health benefits of SES to users were being presented in categorical terms by the applicants. And those views are not shared by the whole community of experts that included their own experts, Ontario's experts, which included some doctors and academics from across the country. And they also cited the Stanford Lancet Commission report. So they said, it's not that there's a universalist view about the benefits of supervised consumption services, something that we obviously disagree with as an intervener, but that they said that it's a complex social issue. There's no agreement on this. They said the evidence was not as rigorous as it could have been. The government lawyer mentioned the need for randomized controlled trials, since he said, quote, correlation does not equal causation. He gave an example of this. He said, there's evidence presented by TNG and the other applicants, that the use of supervised consumption services reduces public injection. Okay, so this was a key piece of evidence given the government's own, one of the foundations of their basis for the law was that, there's a lot of public drug use in front of sites, whereas the evidence shows that the sites actually reduce public injecting. What the government lawyer said was, this is based on correlational data from a survey. It's not based on actual empirical evidence or what he, quote, randomized controlled trials. So you can't really do as much with this evidence, I think was the implication of these arguments. Related to this, he said, even if evidence of the supervised consumption services benefits are to be accepted, its benefits have been exaggerated. So he said, things like evidence that the sites supervise only a small proportion of clients who use drugs. He pointed to KMOP's evidence that it supervises an average of, I think it's 1 to 5 injections per client per month. And what they said, their own experts said, one of the experts attested that her patients inject 6 to 8 times a day. So they try to minimize the health benefits, even if the judge was to accept, yes, there are some benefits, their benefits have been exaggerated. So in conclusion, they said, the picture of benefits posed by supervised consumption services is, quote, murky, and it's not the judge's job to resolve debates between scientists that they themselves have not yet resolved. So I thought that was really one of the key arguments they were trying to make. On the other side, they said, even if the harms to life, liberty, and security of the person have been established, the things that I mentioned before, increased risk of overdose, increased risk of death, increased risk of infection, increased risk of criminalization, even if those things have been established by the applicants, they also argued that these deprivations have also been exaggerated. He said, all that this law does is imposes a buffer zone. All it requires is the province to approve those sites that are municipally run or supported. It doesn't do more than that. He said it was just, quote, a zoning regulation. Even if there's evidence that supervised consumption services have health benefits, there's no evidence to suggest that these health benefits will only be realized if they're located within 200 meters of a school or daycare center. I think I'm paraphrasing a little bit here, but he did say something, the government lawyers did say something to the effect of sites only need to move. And if it's too hard to do that, then they need to look at more, quote, adaptable ways of evolving services, like Sudbury, which was he was sharing working in a mobile unit or trailer. There's a range of responses, and sites have to show, quote, some adaptability. That was a second plank of the argument. So overstating the benefits, overstating the harms. The third piece of their evidence, their arguments, which I found interesting, was how the legislative purpose is defined. So in a charter case, it's really important how you define the purpose, because you have to end up balancing, is the evidence showing that the law is meeting its purpose? So if you define the purpose very narrowly or broadly, the judge has to do that weighing. So here, Ontario argued that the purpose is to reduce the exposure of children and youth to public disorder concentrated near SCS. And the means to do that is to reduce exposure is through the buffer zone, the 200-meter rule from schools and daycares. Other intervenors said the legislation is actually about public health and safety. And so there's broader concerns at play. You can't just be focused on this buffer zone and reducing exposure of children and youth to supervised consumption sites. Other intervenors said it's all about protecting children and families. Ontario said this is too vague. Really, all the act is focused on is location. What they argued is this isn't about prohibiting drugs or even aimed at stopping drugs related to public disorder from happening in a neighborhood. It's location focused and precise. And what they said also was that you can't look at ministers' statements about to determine what the purpose of a law is. And I think it's evident, at least, and I'm speaking on behalf of the HIV Legal Network now. The law itself, I just mentioned there's the 200-meter buffer zone rule and the prohibition on municipalities. But the law, if you look at it more broadly and you zoom out, you see that there is also a provision that municipalities can't request an exemption to decriminalize locally. They can't in particular in safe supply initiatives. I mean, from our perspective as an intervener, the law had a much broader purpose, and it's about an ideological opposition to harm reduction. From the Ontario's government's the lawyers, they said it's about protecting children from, quote, social disorder around the sites. And they said, look at the text itself. Don't look at any other extrinsic evidence. Don't look at what the minister has said. Even if the minister has said, we're not going to approve any more sites in this province under this government, don't look at what other members of parliament, don't look at what the premier has said, look at the text itself. So contain that objective, and then it looks like you're achieving the outcome, right? If you keep the objective really contained and precise. Another interesting thing they said was that Ontario can legislate based on a, quote, reasoned apprehension of harm. The applicant said that the law, when you say the purpose is about reducing the exposure of children and youth to, quote, disorder around a site, you're assuming that the SCS actually does that. You're assuming that the law SCS actually causes this harm. And Ontario said, rather, you know what, we can legislate on the basis of, quote, a reasoned apprehension of harm. They pointed to what they said was evidence. They said the eyewitness accounts that were part of the record. There were a number of neighbors who were providing affidavits that described what they said as the, quote, disorder that they saw in their neighborhoods after the site opened. They pointed to the evidence of the private investigators. I know many of you are aware that they also retained private investigators to surveil around a number of sites in this province, that also with some video and photographic evidence. They said that is also evidence of that underscores a reasoned apprehension of harm that they're arguing. And they also looked at the incident reports themselves of some sites. They also said the Ontario government pointed to one of the criminologists who were among their experts has said that supervised consumption sites attract a drug market, and that this is concentrated at a micro level. So this is what they said justifies them legislating. The applicants did argue there's no connection because there's no proof that supervised consumption sites cause or increase this harm. Ontario said, no, the reason apprehension of harm is not whether the test is not whether they cause that harm, but whether they concentrate that harm in this very specific location. And they called this, quote, a prophylactic and preventative response based on a reasoned apprehension of harm. Finally, and maybe this is just, it's a little bit granular, but the division of powers is an important argument, I think, because the division of powers argument, meaning whether the feds or the province has the power to legislate in this arena, that is shielded from Section 33 of the Charter. So, so say the judge ultimately argues that or finds that there has been a charter violation, Section 7 or Section 15, it's possible that the provincial government could come back and invoke the notwithstanding clause, Section 33 of the Charter, which says that notwithstanding a violation of certain provisions of the Charter, they can still legislate in this area. But that's not true when it comes to the division of powers argument. And so I thought I'd just raise this. What Ontario argued was that there's many binding authorities going back 100 years that say the province does have the authority to legislate to, quote, prevent crime or suppress conditions conducive to crime. And so they gave an example of, provinces being allowed to close disorderly houses for purpose of suppressing conditions conducive to crime. What the Ontario government's lawyers said was, this doesn't actually even close any disorderly houses, it merely relocates them, potential sites of disorderly behavior. And they also said it's well established that the provinces have the authority to legislate around property and civil rights, zoning law, and matters of a merely local nature. Finally, they said, in response to the applicants arguing that this is stepping into the federal government's realm of criminal law power, what they said was, that the Controlled Drugs and Substances Act, which is a federal law that governs drugs in this country, it doesn't create a positive right to operate as supervised consumption sites. It only means that when you get exempted, you're not prohibited. You're not at risk of prosecution. It's not that the practice is, the practice is only merely allowed by the federal government, but it doesn't give rise to a positive right, and therefore it's not actually intruding on the federal law power. It's well within the province's realm to legislate in this way. So those, and then, there were a lot more arguments, but those were the 5 that I thought were quite interesting, and maybe interesting to the audience here. In terms of next steps, it's hard to say. I might point it back to Bill. I mean, obviously the judge ended the day yesterday. You'll have seen from our social media posts reserving and not making a decision from the bench. We'll see whether an injunction will be granted. And if that is the case, then that it would depend on the terms of the injunction, but I'll maybe throw it back to Bill.
Yeah, so we did ask for an injunction to stay open. And the Justice reserved judgment, there was quite a bit of discussion at the hearing about whether the injunction should be granted, because otherwise we have to stop providing services on April 1st. Well, all the sites do, all 10. And so we asked for an injunction to stay open, and we are hopeful. I mean, the whole point of rushing the hearing and to have it before April 1st is, was our intention to stay open until a judgment is made. So we are waiting to see, but we didn't receive it at the hearing itself. There was some question as to whether the injunction would apply just to KMOPS, to Kensington Market Overdose Prevention Service, or to all 10, or in fact, the other sites as well, which can be impacted by the legislation while we wait for a judgment. So that's one of the things that the judge is considering.
We'd like to move to the Q&A session at this point. Okay. Well, first I want to say thank you to Sandra. I know that it can be very difficult distilling 2 full days worth of court hearings, but I know there's a lot of questions, and we're going to get to as many of them as we can at this point.
Thank you for putting your questions in the Q&A. I know that some slipped into the chat as well, so we'll do our best to try to keep a track on those as well and get them answered. So I'm just gonna send the questions to answer live. So can people see
Why
this?
don't I?
Pardon me?
Oh,
This is
sorry, go ahead.
So this is mainly a question for Sandra from Anika Olner. The Ontario lawyers argued that the judge cannot take into account statements made by the Premier and Ministry of Health as evidence. However, just yesterday, a journalist wrote an article about having asked Minister Jones for confirmation of what Lawyer Green had stated, that SCSs could simply move, and she confirmed that her government has no intention of allowing any more SCSs to open or move in Ontario. What does this mean for the case? Is it true that the judge cannot take our government statements into account?
Let me just say, though, because I did speak to the media about this, that it has always been our understanding since August that this is not about moving. This is not about relocation or even replacement. This is about closing. Law is about closing sites. And it's been clear from all of the discussions with the minister, statements from the minister, statements from the Premier, statements from staff. So take that what you will from the government case, but we have always understood that this is not about moving or relocating or inviting someone else to move in and take over. The statements have been there will be no new sites and sites will not relocate. So that's my understanding of everything I have heard for the last 5 months. Sorry, Sandra, I just wanted to say that.
I think that's really important context. And I think that is the how the Ontario government is trying to present that it's so easy, just move. Like look at what Sudbury did. I think practically, it's practically impossible, given what the government has said, that any sites will move or open in this province on the basis of this legislation. I just want to maybe disentangle what the Ontario government lawyer said. Technically, it's true that if you are not municipally supported, if you're not municipally operated, if you're a site like TNG, technically, if you move outside of a buffer zone of 200 meters and you still get your federal exemption, if these a million ifs, you could maybe operate a site under this legislation. And I think they've been consistently saying that since August, like, but what the province has said consistently since August is we're not going to support. And where are they going to get their funding? I think that's the really important piece. Funding was not argued as part of this legal case. So when sites, the majority of them, with the exception of TNG and I think Street Health and a number of other ones that which have since had to close in this province, they're all provincially funded. If they have no provincial funding, what are the chances of being able to relocate or open a new site? I think it's practically impossible. So I think, what does this mean for the case? I think, I hope the judge considers this. It's not just does not look at the technicality of the law, but considers the realities, and all the evidence was speaking to the realities of what this law will do.
And Sandra, one thing that you've said to me that I thought was quite interesting is if all those ifs are met, what happens to that relocated site if a daycare or school opens?
Yeah, but sorry, there's another piece of the legislation that says if a private daycare opens within 30 days, opens, then the site has to close within 30 days. So consider whether Health Canada would grant you an exemption if you don't have guaranteed funding, which is usually from the province. If you have to close within 30 days, you can't show sustainability. And hopefully Health Canada will be really flexible and grant these exemptions. But I think, like I said, there's a million ifs, and I think practically it will make it either impossible or virtually impossible to relocate or open a new site.
Thank you, Sandra. Bill, I'm going to move us along because there's quite a few questions, and I hope that we can get to them all. So the next one comes from Lisa Wright. Have there been other court cases that have considered PTs usurping federal power to create criminal law? Sandra?
Sure. I mean, there was a case actually advanced by the Ontario lawyers yesterday. It's about cannabis regulation and Quebec's. It was called Murray Hall. Went to the Supreme Court of Canada. I can put the link, or we can send it out later if you're interested in just reading a case. But in that case, the Supreme Court of Canada said it was not that the province could regulate. The province came up with more onerous restrictions around cannabis than the feds with the 2018 Cannabis Act. And so the Supreme Court of Canada said that was okay that they could operate in tandem, even if it was more strict than what the federal government had done. In PHS, the Insight case from 2011, that was another line of argument that in that case, the federal government was more conservative and they were trying to shut down a site. And the province argued, this is healthcare. This is healthcare. You can't be shutting down the site. So there have been a number of cases and some that work in the favor of TNG and the applicants and some that don't. And Dylan put the case in the chat. Thank you, Dylan.
Great, thank you, Sandra. We have the next question from Tess Hopkins. If the injunction happens, what does this mean for SCS sites that will no longer be funded beyond March 31st, or urgent public health sites that rely on other sources of funding? Can they remain open?
So the neighborhood group is supported by our community, and we receive donations from the community, and that's how we stay open. Plug, right? So, but along with street health as well, who rely on community donations. So, obviously, if we're successful in this case with the injunction, or generally, people still have to figure out how to pay for it as well, and so will the neighborhood group. But I'll see if Sandra has more on.
Yeah, I think one thing that we should be pushing collectively is that if you have a funding agreement, your site has a funding agreement that extended past March 31st. I don't know how many of the sites have those funding agreements. Going back, if the injunction is granted, going back to the province and saying you should honor those funding agreements, because the only reason why the funding agreement, obviously the funding was withdrawn, was because of this law. I mean, I know there's obviously also many clauses in funding agreements and make it easy for the funder to step away. But I think that's one approach. And collectively, we should also be pushing the province, if their injunction is granted, to keep funding the sites, because that piece, again, is not part of the case. And we want these sites to keep operating.
Thank you, Sandra and Bill. We have the next one from Mary Vaccaro. Was there any mention about whether the provincial government has jurisdiction over UPHNS federal sites? Throw that to Bill or Sandra. I'm not sure who's the best to take that.
So urgent public health sites, it was mentioned, it's not, I don't think it's mentioned, well, I don't know if it's mentioned specifically by name in the legislation, but I am concerned that it falls under the broader issue of support from the municipality, that whether something is supported by the municipality either by offering space or staff or money or permission. But that would be a legal question for Sandra. But I understand early on in September, the minister was quoted in the media as saying that those sites are included in this legislation.
That's right, Bill. It is included in the legislation. So if you are, even if you get your exemption via the federal government as a UPHNS exemption, if you're within 200 meters of the buffer zone, or if you're supported, like you said, then you're still affected.
Great, thank you. The next question, I'm not sure, I can't put it to live, so I'll just read it out, is from Stephen Biss. Can you, oh, I'm sorry.
I think Sandra was able to answer that one quickly, and it's already answered in the chat. Thank you, Sandra.
Oh, okay. So if you see your question going into the chat and it's been answered, not live, but this way, that's where it is. Sridevi K, regarding the randomized control trials comment by the government, would it be helpful to create a living database of research evidence that speaks to the importance of SCSs and lack of surrounding harms? A lot of researchers, even based in Toronto, have done a lot of work in this field. Bill, would you like to take this one?
Sorry, I was reading the chat. Can you repeat that?
Oh, it's just a question about creating a database of research that speaks to the importance of SESs and lack of surrounding harms. There's definitely been a lot of research done. Dr. Werb
Yep.
was quoted yesterday.
Yeah, so there definitely has been comments made that there's differing opinions on this. It does seem to me that this is one of the most studied social services I've ever come across, and that there are, in fact, lots of studies and lots of evidence. But until people get the answer that they want, some people continue to say that there's not enough evidence. So, but it seems to me that there is a lot of evidence. And it certainly would be no harm in gathering it together and collecting it, but I don't think it's a lack of evidence. I personally don't think it's a lack of evidence that is holding us back.
We are at 12:45. There's still a few questions, so we will stay on to answer them. If people can remain, that would be great. We really appreciate your support and enthusiasm and wonderful participation today. Arwin McKechnie has said, I appreciate the flag on where the injection would apply. Apart from the site slated for closure, SCSs who aren't planning to close could be shut down if someone puts in a daycare within that 200-meter radius to the harm of their clients and communities. Not sure that that's really a question. I think just...
Yes, I think that's just reiterating what Sandra had said earlier about, the idea that if something were to come in, a new daycare open, then the kind of ifs start all over again. And they would be forced to close within that buffer, within that newly redefined buffer zone by the new site, by the new daycare or school site.
Right. Great. Thanks, Janet. And the next question sort of, I think, follows up on that a little bit. Is there a concern that the government will eventually seek to close all CTS locations in the province?
Bill, I think you answered that question.
Sorry, again, I was looking at the chat.
Yeah, is
Yeah,
there a concern that the
that's-
government will eventually seek to close all the CTS in this province?
Yes, is that fundamentally that's why I'm here today, why we agreed to do this charter case, because there are the cases that are the sites that are currently at risk, but all future sites are at risk because people's leases expire and they will not be allowed to relocate. A childcare could open up next door and they will not be allowed to relocate. They could run into funding problems and they would not be allowed to go to the city for support, any city, any municipal for support. So it really is, I mean, already more than 10 sites are at risk of closing next week. So there's the 10, but there are other sites as well. I put in the chat that the site in Peel, which is an urgent public health site, is also closing, even though it's not within 200 meters, because it is an urgent public health site. It was supported by the municipality. So it's this creates a pathway of closure one by one of sites. Any sites that's supported by municipality or located within municipal offices. Anyway, so I do fear that is the risk, and we need to challenge. And of course, I'm also challenging the basic question, and people have heard me say this before. The childcare closest to my site is run by the neighborhood group. We have demonstrated that for 8 years, you can have quality, safe childcare and quality, safe healthcare in the same neighborhood. And so there's a fundamental error in this law. And that is what we are fighting about. But as long as we accept this error, that somehow you cannot have healthcare and childcare in the same neighborhood, then all sites will one by one be at risk of closing until there are none. And so that's why we're here today. I also just want to share, so Aubrey is with us today, my co-applicant, and he asked me in the chat to thank everyone Thank everyone for their support. Thank to the very hardworking pro bono legals team who worked with us. Thank you to all the intervenors who said what had to be said, that could speak for more than what Aubrey and I could say. And so I share Aubrey's thanks to everyone for that, and HIV Legal Network for guiding us along this path when we're total novices on this, and thank you for that.
There are quite a few more questions in the Q&A that we would be happy to send out answers to afterwards, just in keeping in mind that we want to respect everybody's time. So I think that unless Bill, Sandra, and Janet, you want to continue on, we can just get the send these out afterwards to all participants and post it on our sites.
Yeah, there was one question there that I think is important. Sandra addressed it earlier, and it's around what happens next. We do have a backgrounder on that. I'm hoping that our colleagues can put that up in the chat again, the backgrounder on what could happen next in this case and beyond. But I'm okay with that. I'm also conscious that we're starting to see some drop off. I also wanted to say, I again reiterate the thanks to everyone who's put so much into this case. We've been talking a lot about law. I'd like, before we leave, to turn it back to talk a bit about people, real humans, friends, loved ones. I know all of us feel this way, lawyers and non-lawyers alike. We've lost so many people. I'm wondering if we can take a minute together just to remember those who have been lost and those who continue to be harmed by this legislation.
Well said. Thank you so much, Janet. And thank you, everybody, for your support, for your thoughtfulness, for your caring, and for really stepping up to make a change. We've had a number of comments and questions in the chat about what can people do to help. There's different things you can do. You can speak out on social media. I know many of you have been following us closely during this charter challenge, and hope that you continue to do so beyond and really amplify the work that so many wonderful groups across this province are doing. You can talk to your MPP and demand evidence-based drug policies. Policies that will save lives. And you can donate to support us and to support the work that we're so committed to doing, and to doing it together with our community. I'd like to thank everybody for joining today. Huge thanks to Bill for being our tireless leader, and working so hard to bring this issue forward, to Katie and to Aubrey. Thank you for your bravery. It's just so inspiring. Thank you to our wonderful legal network colleagues. You have HIV Legal Network colleagues. We couldn't have done it without you. To our law teams for the pro bono support. I know I'm missing so many people. To all of our people who stepped up to back us. Yeah, thank you.
Thanks everyone for joining us today. We'll probably hold a debrief of some kind when we get our answers.
And we will be posting things on both of our websites. We'll send information out to you after this. We'll send the recording. We'll get the Q&As done as quickly as possible. Yeah. Please reach out anytime. Ridley's put a couple links there. Perfect. In the chat.
And that's a wonderful idea, Bill. We should do a debrief once we hear more. Okay.
Great. Thank you, everybody.
All. Bye.